Nobody. Welcome to the premier program of Dial a Lawyer. Welcome to the premier program of Dial a Lawyer. We have with us this evening three distinguished attorneys who volunteered their time to take calls live from the general public. The purpose of Dial a Lawyer is to provide some helpful information to callers who maybe are unsure whether they need a lawyer or can't afford the services of a lawyer, and provide some information on the nature of legal services to the general public, have it be educational, but also we hope it will be entertaining. I'd like to introduce briefly our speakers. Seated immediately to my right is Ralph Kirscher, who taught bankruptcy last year and is our specialist in that area. To his right is Jim O'Brien with the O'Brien Law Office, and to his right is Karen Townsend, who is a deputy county attorney in the Missoula County Attorney's Office. If you have legal questions or need advice on what you think may be a legal problem but aren't sure, we would encourage you to call us, and the number, which may be, I hope, on the screen, is 542-6228, and that's simply 542-MCAP. We will indicate at the outset that we are not guaranteeing the accuracy of any information that's provided this evening. In fact, if we had to, we would guarantee its inaccuracy to try to have an adequate disclaimer. We don't expect to be able to give full-fledged legal advice like an attorney normally would in an interview, and we just can't do that in this short a context. We're going to try to provide some initial guidance and direction, as much help as we can in this limited context. And it wouldn't be legal advice like you'd get from an attorney after a full investigation of the facts and further research into the law. Make a quick comment on the type of questions that we would anticipate. Obviously, we wouldn't be expecting questions of a business or commercial or antitrust or complex nature. We're looking for what we'd call human interest legal problems. If you have a problem with your landlord, if you have a concern about bankruptcy, you've got a lot of debts, don't know what to do, don't know whether you should file bankruptcy, we have someone who can respond to your questions in that area. We have an expert on criminal law here, obviously. And so if you have problems in these areas, feel free to give us a call. As I said, if you're not sure whether it's a legal problem or not, feel free to call us, and if we find that it's not something that we know an immediate answer to legally, but there may be some appropriate public service agency or private philanthropic group, we'll try to suggest an appropriate agency that might give you an adequate response to your question. It looks like we have a call coming in on line 1 and also line 2. We'll take line 1. Oops, in a moment. I guess it takes a little time to do the hookup here. Just keep your call there coming. Do you know which line it is yet? Not yet. It takes a minute. Don't give up on us. We'll get the high-tech system worked out. Line 1, okay. Line 1, you're on the air.
Yes, my question has to do with how one determines if you should have a trust or a will or both of them.
Okay. Any of you want to grab that one? Ralph?
In response to your question, one has to really consider the assets that you may have, also the income that you may have on a periodic basis, and also how the properties are owned, whether they be in joint tenancy or if they're held in your own name individually. And also, as I indicated before, the total number of assets that you would have. In some cases, a trust may be appropriate. That does eliminate the need for probate, but you do have to do reportings to the State Department of Revenue and possibly to the Internal Revenue Service, depending upon the magnitude of the estate. If you have children, if you want to designate guardians, you should have a will. If you don't have children that are under the age of 18, it may not be necessary. However, I still would recommend that you consult with an attorney that handles such matters to determine if, in fact, it's necessary.
Thank you.
Okay, we'll take a call on line 2. Line 2, are you there? Beeping, hang up. Oh, it's still there.
Hi, I don't know if
Okay.
you're going to be able to answer my questions or not. It's about workman's comp,
Okay.
okay, and it's through Alaska, and I haven't been able to find an attorney in Missoula to take a workman's comp from Alaska. And so I found one, and that was 3 years ago because the suit's been going on for a long time. And then he told me that he wouldn't be able to litigate in Montana. He would have to find a different attorney that could litigate in Alaska. So he turned it over to another party, his firm, which is in Seattle. And then she called me up and said, now they can't litigate it. And so I'm supposed to try and find another attorney here in Alaska. Here in Montana. So I've gone through like the legal thing in Helena
referral?
Service,
Yes.
and they don't seem to know anyone either. Is there some way I can find out, or someone could maybe take my number and call me or something?
Before we answer that question, Jim, could you tell us whether or not you've tried to obtain an attorney in Alaska to work out the Alaska workman's compensation case?
Did you hear that question, ma'am?
Yeah, that was suggested to me, but then when I talked to Work Comp up there, they said that there were attorneys down here that could handle it, and so then I got an attorney down here, and then when I talked to the Seattle branch of this attorney that I had down here, she says there has to be someone here in Montana that can do that.
Any other thoughts, guys?
Well, what I would suggest is maybe, again, trying to get a local attorney at least to help you deal with the medical and the vocational opportunities that are going to come down here. I don't know where you might get an attorney who would do that. And I would suggest maybe calling attorneys locally here in the Yellow Pages, finding out whether or not they do workman's compensation, and present that problem to them and say, I anticipate that I might need an attorney in Alaska as well. Could you help me out?
Okay, this has been going on for 3 years, and I have a firm that's here in Missoula, and then they turned it over about 2 months ago over to their Seattle firm, and now their Seattle firm is telling me that I have to find another attorney.
Well, that does pose a difficult problem if you can't arrange to do that. I guess I'd say just continue to contact the lawyers locally here and see if you can get some help. I don't know how extensive your search has been, but I wouldn't give up.
It's been pretty extensive.
Excuse me?
It's been very extensive. I've called almost every attorney in the book.
Why, then I'd be at a loss for additional ideas. Do you have any?
It not only has to be for work comp, it has to be for the marine thing too, because there's some kind of marine laws that when I got hurt that they weren't following. So there's going to be like two kinds of suits going on there.
I'm not aware of a specialist in Montana who has expertise in maritime law, and that is what you're talking about, is maritime law.
I had a maritime law case once back in law school, but it was moot court. Well, ma'am, I think that Jim's suggestion of looking carefully through the portion of the Yellow Pages under attorneys where they list specialties is a good one. In addition, every lawyer has what's called a lawyer's desk book, which has kind of a more detailed listing of specialties that attorneys hold themselves out as being knowledgeable in. And if you were able to just get a hold of one of those books, that would give you a comprehensive list of attorneys. I can't think of any other answer at this time. Looks like we lost our call on line.
Oh, I'm still here.
Okay. Yeah, I would just suggest you just need to keep plugging. The one suggestion I would make in general to people calling into the program is that if you do have a problem, that's serious enough to warrant getting a lawyer, you should try to get the very best one you can within that specialty area and not just take anyone. It sounds like you've made an effort to do that,
Uh-huh.
and I guess there's no other answer than continuing to pursue that inquiry.
Okay, well, my suit has to be filed before the 31st of this month, so they were going to file it over there in Seattle, but they told me that I have to find someone before the 1st of June.
Wow, there is some urgency.
Yeah. Otherwise, I'll lose my suit because it wasn't filed.
Well, I guess you could call any one of us individually to try and get some other recommendations. I know we all have people that we would recommend in certain specialty areas, but we wouldn't want to do it on the air, ma'am.
Okay, I'll call one of you tomorrow. Thank you.
Okay. You have a call on line 1.
Hello.
Hello.
Yeah.
You're on
Say,
there.
that poor lady I just heard on the air just now, she has a work comp problem. It's not really a problem. What she needs is a local attorney to handle the situation down here for her and a correspondent attorney in Alaska. And this maritime thing she's talking about is obviously the Jones Act, which is a federal workers' comp situation. It shouldn't be a problem at all for some attorney down here, any attorney, doesn't have to be a specialist in work comp because the work comp laws of Alaska are going to apply. And all she has to do is get any attorney who's got sense enough to compile the medicals for her and so forth, and then work with the correspondent attorney in Alaska, which there are a number of them that handle the Jones Act up there. And she shouldn't have a problem. And
Well, we hope you're right. It sounds like she does have a little immediate problem. We welcome your comments, and we'll take a call on line 2.
okay.
Line 2, are you there?
Yes, I am.
Okay.
I was wondering if you could tell me, my husband and I are going to separate. Do we need like a legal separation, or what would be the advantage of not having anything?
If I might, Jim,
Yeah.
I would suggest that if you see that much of a change in your marriage, that it would be appropriate to go see an attorney. Many is the time that people think they're resolving their matter completely by just making an informal agreement. Later on, sometime down the road, they'll find themselves to have given a great loss or lose an awful lot by the virtue of the fact that time has gone by. Children, if you have children, it's very important that you deal with that.
Okay, we have children, but they're by my first marriage.
Okay.
But mostly I'm thinking about like for income taxes, and I don't want to be liable for any debts that he might incur while we're separated.
That would be a real reason why you would want to go to have an attorney at least hear what it is that you have agreed between the two of you so that he can give you some specifics about the advantages of doing it the way you're proposing, that is, just informally.
Okay, thank you. Bye.
Still have a call on 1. Okay, line 1, are you there?
Yeah.
Okay.
I'm calling about that woman who's having a problem with her workman's comp.
Yes.
I also had a problem with my workman's comp. They were having a hard time deciding if it was work-related or not.
Yes.
I called my father's lawyer, and she is one of the few in town that will take on any type of workman's comp.
Okay. Well, we appreciate your comment.
Okay.
And in fact, we would welcome comments from listeners. If other attorneys listening in think that they can add some comments to ours, we certainly welcome their comments. Many legal problems are not strictly just legal per se, but they may involve aspects of knowledge of family relationships, the sociology of a problem area, or the economics of a problem area. And so if other professionals in those specialty areas are listening in and wish to comment on the answers, we welcome those comments also. Is that line 1 off now? Okay, thank you, ma'am. Oops, did I kill him? I probably killed him, huh? We'll try again here. I may have cut a person off. Just call right back, 542-6228. While we're waiting for a call, I guess we've got a couple of discussion topics here. Maybe our panelists could comment on, well, in general, how can people find lawyers?
I think sometimes it's hard because you don't know where to start. You can look at the yellow pages and find a whole list of people and an alphabetical list, but how do you know who's a good one and who can help you? But that's one place to start. Look and see what their specialties are, and as Jim, you suggested earlier, try and find out who the best person is for the problem you've got. We have a organization or a place in Montana called the Lawyer Referral Service, which is out of Helena, Montana. The phone number's in the phone book, and you can try there to see people who are willing to take their problems. Sometimes you need to ask a friend, someone who's already had a lawyer, and maybe they can give you that kind of referral as well.
Mm-hmm. All right. Can we comment for people? I mean, people may have no idea how much lawyers charge. What's a typical initial consultation fee, Jim, in Missoula?
My experience is most attorneys are willing to consult with the client or the prospective client in order to get a sense of what the problem is without charge.
Mm-hmm.
I think,
I would-
Ralph, would you agree with that as a practice?
I do. It depends on the extent of the advice that needs to be given at that first conference, but that's something that should be discussed between the client and the attorney right at that time.
You have a call on 911 we'll take. Yes.
Hi, can you
Hi.
tell me if you go to a psychiatrist or a psychologist and you have something that you want to talk to them about and a crime has been committed either by you or somebody that you know, are they obligated to tell the
Mhm.
psychologist or the psychiatrist?
Part of that depends on what kind of crime might be mentioned. Montana has what we call a mandatory reporting obligation if there's a sexual offense involving children. So if a professional such as a psychiatrist or a psychologist learns that a child has been abused or molested, they must, by law, report that to Family Services Division. If it's other kinds of offenses that does not involve the injury or sexual molestation of a child, then generally what you tell a psychiatrist or a psychologist is confidential, and the information that you disclose cannot be used against you in some sort of criminal proceeding.
Can you tell me what type of child abuse you're talking about?
I would be talking about any kind of child abuse where you have a child who's the victim. It could be sexual, or it might be physical, it might be neglect. Any of those three would come under our mandatory reporting laws.
Thank you.
Mm-hmm.
There is a statutory privilege, isn't there, in general, aside from that mandatory reporting statute?
Things other than the child abuse, yes, you would be privileged.
Mm-hmm. I believe there's a case out of California. It's called Commonwealth or State versus Tarasoff that also has some kind of implied duties where you think somebody might be a threat to kill somebody.
Right. I guess that would be the only time, and that basically is a reporting because of potential civil liability against the doctor who
Yes.
doesn't warn the person who might be injured by someone. It has to be a pretty direct threat, and not some sort of vague threat in the future. But that wouldn't be compelled by law. It would just be the psychiatrist trying to prevent himself or herself from being sued for any injury that might happen that he had learned about.
Right. Okay. You were stumped for questions for lack of questions. Maybe could somebody on the panel comment on how lawyers typically work? How, if somebody calls you up and comes in for an initial consultation, and how does it work typically? Just so they get a feel of how it happens.
Well, in response to that, once the initial consultation occurs so that you know what the issues are, what the facts are, hopefully at that point, although you may learn of facts subsequent to that meeting that would warrant further research or investigation. After the initial consultation, one would typically, at least in many of the firms, enter into some type of fee arrangement and a documented agreement whereby the attorney would be undertaking a specific task for that client. And then there would be follow-up with the client if additional information was needed, or an opinion given based upon the facts that they're aware of at the time. That's how at least we work in our firm.
Is a written retainer agreement a good idea both for the attorney and the client?
We have found, well, we mandatorily require some type of written documentation agreement between the client and our firm, so that there's no misunderstanding between the client and us as to what we will be providing them service for.
Okay, well, we're welcome for your calls. I think the number should be on the screen. It's 542-6228. We still have at least maybe 10 minutes before the program time runs out. And in case I forget before we wrap up, I'd like to thank our panel of volunteers for being with us this evening. Thank you, Karen, and Jim, and Ralph.
Jim, I think, sort of follow up what Ralph was saying, the important thing that the lawyer has to know is what the facts are, okay, before you make any kind of a decision. And so that, in some degree, requires you to visit with the person to find out what has happened. Then you may have to go to the law books and find out what you can do legally to solve this person's problem. So you have to make sure you understand what the problem is before you can help them.
Okay, we'll take a call, line 1. You're on the air.
Thank you very much. Yes, I have a question. I don't know what type of, I think it's a probate or something like that. I lost my mother several years ago, and I've got a twin brother. And how do I go about getting the things like the house and stuff transferred to both of our names?
Well, if I understand that the brother has died.
No, I haven't. No, I said my mother.
Oh, your mother. Has your mother died?
Yes.
Okay. And the property was in her name?
Yes.
Then it would be necessary to, if that was not held in joint tenancy, then to probate through a judicial proceeding to have that property conveyed to whoever her heirs would be, or whoever was designated under the terms of the will.
That would be, she didn't have a will, and that would be my twin brother and myself as direct descendants.
Okay.
We were her children.
Okay, as a result of the fact that there was no will, then there's also a procedure under the Uniform Probate Code where that passes by what we call intestate succession, which would pass to you and to your brother most likely equally. But it would still require some judicial order and then a deed of conveyance of that property from whoever the personal representative is of your mother's estate to you and to your twin brother.
Well, see, the other, there's also a kind of a stickler in the situation. My brother right now is over in the state hospital, and I don't know how to handle this portion, like, because I want him to, the house to be transferred to both of our names, everything divided equally, like the way she wanted it and everything.
Well, is he under court supervision through either a guardianship or a conservatorship?
I don't understand what you mean by that.
Well, many times when someone is, and I'm not sure of the reason that he may be in the hospital, but if he is not competent or is unable to understand what is happening, around him, or would be unable to handle his affairs, there's also the ability for that person under the disability to have either a guardian or a conservator appointed. And since you're a twin brother, it would appear that probably you have some priority in having yourself named if that is determined to be correct by the court.
Well, the thing is, what I was trying to look out for was also his interest and stuff like that. See, I wanted to do what she wanted to, and I wanted to do what's morally and ethically and legally right for him too.
Right, and that's something that would be determined through that court process, and having you or an appropriate person designated as either the guardian or the conservator.
Well, then how would I do? Would I just contact a lawyer? Would this be handled through a probate or something like that? A lawyer that deals with probate, or how would I?
That certainly any attorney that handles probate would be able to handle that for you. It may involve more than just a probate. It may involve a conservatorship or a guardianship as well for your twin brother, depending upon his state of mind and capability.
Well, I think see, just over there, getting straightened on some medications and stuff like that, and that's what I've been trying to. I didn't know how to handle it or anything like this. Something that just and like I said, that the mother died without leaving a will. But I mean, I knew that technically that living errors and stuff like that.
Well, I would recommend that you contact an attorney, and I'm certain that in the yellow pages there's a reference to attorneys that handle probate.
Okay.
And discuss that matter with them and set an appointment to see them.
Okay. Yeah, I think you've answered my questions there. Thank you
Okay,
very
thank
much.
you for your call. Is line 2 ready? Okay, line 2, you're on.
I tuned in late, so perhaps you've already talked about this, but I think one of the things that alarms people about seeing a lawyer is what it's going to cost. Have you talked about any kind of scale of what you can anticipate when you go in to see a lawyer?
Sure. I think, yeah, we talked earlier on the program on
Sorry.
regard to how some lawyers have no initial consultation fee. I think that other lawyers, if it's not a multi-million-dollar brain injury case, will have some initial consultation fee from $25 to $50.
Jim, I would add to earlier comments that simply going in, making the appointment with the attorney, or speaking to him on the phone in advance of an initial consultation about how they charge, it's my experience most attorneys will be real upfront about their
Sure.
fees.
Good. Okay, fine, thank you.
Sure. Line 1, is that ready? Okay, line 1, you're on.
Hello?
Hello.
Could you tell me if my ex-husband has a judgment against him for child support, and he received a payment from Social Security, a large, lump sum payment, is he obligated to pay off that lien for child support, for back child support? Or can I attach that?
Generally, Jim, the child support liens attached to property of your person such as your husband, you can't get, generally speaking, Social Security to turn over the money to you. Once the money is given to your husband, however, you could enforce that child support lien by going and bringing it to the attention of the judge, who would then authorize its seizure. But as a general rule, I think Social Security claims or Social Security proceeds are not subject to the
Immediate attachment.
the immediate attachment. That's correct.
So when you get a Social Security payoff or you get Social Security monthly payments, does not part of that go towards if you say that you have 2 or 3 children? I mean, I think that he said he has these 2 kids and then got the money and never gave any of it to them.
Well, the way the Social Security system is structured, if the children are underage and he is receiving disability insurance, they will separately receive a monthly payment to help through their support. And in Montana, the courts have recently indicated that those payments will be credited for current child support, but it would necessitate you going to court and having the judge made aware of the circumstance so that you could have the checks sent directly to the children or for their benefit.
All right, then thank you.
Thank you for calling. One other general topic is, since we don't have any immediate calls, I think. Oh, we do have one on line 1. Oh. Try again. I see nothing flashing. Okay. There is a means of getting into court without lawyers, known as small claims court. And maybe Karen, could you tell us about how that works?
Well, small claims court is part of our Justice of the Peace Court and designed for people to come in and settle a dispute without getting lawyers involved. Now, there's a limit on the amount of money that can be involved.
What is that, do you know?
I think it's $750 for the maximum amount that's at issue. And you come in and tell your story to the judge, and the judge makes a decision about who should win. So it's an attempt to handle small amounts in that way.
We'll take one more quick call. Oh, I guess we won't. Oh, it's not ready? Looks like we're about to wrap it up then here. We appreciate the calls. It looks like it's been a good evening, and we very much appreciate the participation of our panel of volunteer attorneys. Again, thank you, Karen and Jim and Ralph. And this has been the first live call-in talk show in Montana, to our knowledge, and we've enjoyed being here. If we seem a little nervous, it's because it's our first time. Next show will be June 30th, at the same time, 7 p.m.